Great.
Amazing.
Okay, let's get started. We're waiting to 10:05 to allow for another meet to come in late. Hi everybody, welcome to the SPAC. First in person since, what's the technical term? The SHIT hit the fan in 2020. So we are very glad to be here and see everybody and have all this time for socializing, because we missed out on this. I'm Marta Venegas. I run the Venegas Law Group. I'm the chair of the business law section, don't ask. With Joe Snyder, who is one of my former bosses, we arranged for this wonderful seminar for you. So we had a plan to have two speakers, but one of those speakers was called to court and cannot be here today. We thank her for her contributions. Let me just check, name check, because I can't remember anything anymore.
Ashley Shively.
Ashley
Shively.
Shively, yes. It's right there? Yeah, okay.
Next one.
Good job, Marta. Next, let me introduce Lee Lueddemann to you. Lueddemann? Yeah, something like that. You can butcher my name. Lee's a data privacy and intellectual property attorney at Brother Smith, and he also has his own practice. Also a law professor at Lincoln Law School in San Jose. His practice provides practical and innovative strategies for technology and science companies. Acting as independent general counsel, Lee works closely with his clients to create realistic and useful policies and procedures for data security and privacy. He secures their intellectual property. He assists with entity formation, commercial documents, complex contracts and agreements, licenses, negotiations, and management of outside counsel. He is a certified privacy professional, a registered patent attorney with successful experience in prosecuting and protecting patents, trademarks, and copyrights worldwide, and probably one of the few people who have more legal education than me, and he is actually using it. I am so delighted to introduce you to this presentation today because we had a business law series this year in which we studiously avoided all privacy concerns because we did not want to go into it. So here we go, we are going to go into it.
Well, good morning, everyone. I'm actually glad I got to speak to a few of you earlier. A little bit about myself. I just moved to Eagle, Idaho. So, like you've heard of the Californians that are moving to Idaho and Tennessee and stuff, here's one of them. So you can see for yourself. If you haven't met one of us yet. I'm a fourth generation Californian, so it was hard for me to move, but I'm here usually at least once a month, sometimes twice a month. Having said that, I will be following, and I guess it's a little bit of an apology up front. I will be following the slides, not all of them, because of a last minute change. However, I promise it'll be interesting and useful for you. So let's get started. And by the way, we are such a small group. I don't flinch at interruptions. If you have a question, stop me. I will bring us back on track as needed, but I want to make it interesting to you. In fact, let me lay out my goal first, because I really like having a roadmap before I do anything. What I want to do in this presentation in this morning is, how many of you actually, let's start with this, practice privacy law? Oh, excellent. So are you a litigator, or do you do the policies, or all of the above?
Former litigator, and just do mediation, arbitration work these days.
Oh, perfect, okay. So and I'm just curious, but with the rest of that, my goal typically when I sit in these things and look at laws that are interesting and relevant to me, but that I don't practice in, I want to give to you, and that is when you're looking at these, just like law school, I don't expect you guys to go out and practice privacy. My goal this morning is to help you understand the fundamentals and then go through and recognize the issues as they come up. So if you're talking to one of your clients or going through, you get issue spot and you won't ever hopefully get, you're the attorney, why didn't you? Now look where I'm at. You know, I want you guys to see that, I want you to recognize it, maybe do some work beforehand before you hand it off, which we're also specialized, that's what we do anyway, right? We issue spot and we find somebody who can do it for our clients if we can't as well. That's my whole goal this morning. I initially wanted to put a little bit more intellectual property into it. I can go that way if you want. So as a patent attorney, I'm a little different in that I draft my patents, my trademarks, or any other type of prosecution I do with a business goal in mind, with a license in mind, because the goal is to make money for my clients. So all of that is slated in there. They stick around, they're happy with me, and I get to keep a client instead of writing one off. I'm not going to go there very much. We can if you want. I'm happy to answer any questions. Like, I would rather have an open dialogue and interruptions than putting you guys to sleep. Having said that, there's a lot going on in privacy, and you will see I added a heavy dose of California law, because how many of you, I know one of you has at least, have heard of the CPRA? Everybody, right? Do you know when it's coming into effect?
January 1.
That's right. Just a couple months down the road. So, we're going to go through the CCPA, which is the law that's in existence now, because a lot of that has to do with CPRA. We'll get there in a second. So, the roadmap that I promised earlier. I want to go through and give a brief introduction. We're going to go way back into fair information principles. These started in the early 70s. And the reason why is because by the time we get to the end of the presentation, I really believe this is coming down the pipeline for me and all of you. Over the summer in August, the New York Bar just required, do you guys know what I'm going to say? That each New York attorney takes 1 hour of data privacy, data security. That's required for their CLE. They're the first state. It's happening next year, I believe, yes?
1 hour for 3 years or 1 hour every year?
I think 3 years. I'm not barred in New York, but I'm assuming it's 3 years. Like us, right? We have, for 3 years. I think that's coming in. Too bad I can't count this for when it does come into California. But what I want to do is I really am going to work at saving a bit of time at the end, because as I go through what New York is requiring, and I want to be able for you guys to go through it. And of course, this is what's relevant to you and your law practices. To protect your clients, to protect your business, this is what New York sees as valuable for their attorneys. They have an outline. When I'm done with this, I hope we can go through the outline and you look and you say, well, it's not going to be on a slide. Like I said, I had to switch it up a little bit. But you can go through and say, yeah, okay, that makes sense, that makes sense, that makes sense, that makes sense, and anticipate what's going on by the time I'm done.
Can we log on to the New York State Bar Association's website and get an outline from there?
Yes, absolutely. I think I have. Here's what it looks like. I don't know if you can see it, but it's a couple pages, and I'll go through that at the end. I don't have the website printed out, but it's New York State Continuing Legal Education Board guidance relating to the new cybersecurity, privacy, and data protection category of CLE credit. So it was not hard to find. But that's my goal for the end. So, brief introduction, fair information principles, which have guided all this. In fact, you will see one of the big reasons, in my opinion, why the CPRA was updated from the CCPA is to include more fair information principles, starting in the 70s. After we get through that, we'll take a long stroll through California law, because it's just around the corner, and it relates to your practices and your clients' practices. And then we will touch briefly on, we'll do a 7th inning stretch if we need to. We'll touch briefly then on what's going on in neighboring states, the new law in Canada that's coming up, which is similar to GDPR, and also a little bit, if we have time, of what's going on at the federal level, tiny bit, and then we'll hit New York. So that's really where I want to go. Any questions? Okay. And by the way, you don't need to raise your hand. I was a litigator for long enough in front of judges that I had to get used to being interrupted quickly and think on my feet, because they love to pound us state prosecutors. So in Florida, many, many years ago, so it doesn't faze me a bit.
Hey Lee,
Yes, sir.
just so you know, I don't have clients. I work for a federal agency.
Oh, great.
So when you get to the federal part, I'll be paying rapt attention to that segment. I just want you to know that there's at least one person ready to hear all of it.
Don't you have at least one client, like all of us that are paying?
Yeah, we pay your salary,
The
too.
client is the United States, yes.
What, I used to work for the Fed too, what agency?
U.S. Attorney's Office.
Oh, okay, I was in Social Security. So it's very, very little on the Fed, although it's peppered throughout because clearly it's important.
All right.
Thanks for being here.
You're welcome. Thank you.
Until then, you're sleeping.
No, I'm taking it all in, yes.
So, let's get started, and I apologize, I'm going to read a little bit more than I normally would because I switched this speech up just a few days ago. But I hope to promise it'll be interesting. So, regarding privacy, as I alluded to, it's a patchwork of laws, not just country to country, but within our own country, between different agencies, and then laws are always passing, they're always getting updated, and then into states, and then a patchwork of laws within the states. So what I alluded to is really as a solo and at a small firm, most of my clients are small. They don't have money to keep chasing after. Every time it changes, reactive. And so I have adapted to be able to do something that they could afford. I've been doing privacy for about 20 years. I started when I was general counsel of a pharmaceutical company around the turn of the century. So, and I had to do a lot of HIPAA and other things with all of our clinical trials. And after that, it's whether I've enjoyed doing it or I've had trouble escaping it, I've done it in probably every single job I've had since then. Which I enjoy things that change rapidly, it keeps it interesting, and this area is always changing. What I was getting at with these small clients is if you understand in my opinion, if you understand the fundamentals and you look at what's going on, generally I think you can get a good feel and anticipate what's going to happen next, and you can plan for it. In the same token, if I can give you a general idea and feel of what this is all about and where it's going, you will be able to not only issue spot, maybe not 100%, but generally, and also anticipate where it's going. When you see something, you can say, okay, then maybe that's not California, you're not doing business in Massachusetts, but I can see this coming along. So, having said that, even though it's a patchwork, we can find common threads. And hopefully that way you stay out of, at least in California, the new agency as of last December, the CCPA and the Attorney General. So the times have changed and the laws and patchwork from when it was and when I started doing privacy have made us realize that how much the government scrambles to keep up with technology. On one hand, for those of us that remember Edward Snowden, I'm sure we all do, he actually showed the public how much information the federal government gathered on us and made it, and actually changed a lot of things and put the ball into motion. Regardless of what you think of him, they were gathering a lot of information, as everybody still does, even with the recent case of Sephora taking information. So it continues on for whatever reason. And so it's important to realize, and as you'll see these changes go through, they give more and more power to people holding over their own information and controlling it. So, privacy is not just, I'm sure this is probably, hopefully a refresher for all of you, social security number, email, password, but also your geolocation, your cell phone, where you are, where you've been, who you've called, etc. It's not expensive to get a cell phone tower dump that doesn't necessarily require a Fourth Amendment to get a tower dump for all of your information. And it's a lot cheaper than putting somebody to sit outside of a car in front of your house. So all this is privacy information. And so it goes on, and not just that, but inferences into privacy information as well. So let's look at privacy and data security. So privacy. We all studied privacy in law school. It's the same privacy. It's the same privacy that came up when we were worried about British soldiers being quartered outside of our houses, securing our papers and effects. It's the same privacy as eavesdropping, listening to a telephone booth. It's the same idea. We're all familiar with this. It's just changed a little bit and updated into the information and what they can do with it, how they gather it, et cetera, that we'll get into later. So, privacy and security are intimately related, but they're not the same. Anybody want to take a stab at trying to define the two? I had trouble before I came up with a good example. I love this example. I heard it, it's not mine, but I stole it because it's the best one I've heard. So, it's an example of a house. This is an idea of security and privacy. If I walk on a sidewalk outside of any of your beautiful homes, let's say you have a whole lot of windows. You draw all the blinds and everything else. I can't see inside, but I see a brick down there. I pick it up and throw it through your window. You had good privacy because I couldn't see in. You had bad security, right? You fix your windows that I broke. You put up, I don't know, security cameras, wood shutters that are going to withstand bricks. You put up a big fence and a wall and everything else. I can see over it, but I can't get into your yard, and it's too far for me to throw a brick because I'm not that strong. However, you leave all of your curtains open. You have good security, bad privacy. Does that make sense? I love that example. I think it really makes it clear. So, that's the difference between privacy and security. How does this relate to data? I saw, and this is a really old TED Talk, but one way how we can relate security and privacy to data is this TED Talk I saw many years ago, and it made an impression on me. And this guy was talking about security and privacy, and he said invariably, after every presentation I give, I need to make sure I stay within my time limit. Within every presentation I give, somebody says, look, I don't care if the government knows whatever, I have nothing to hide. He said, if you have nothing, have you heard this one?
Yes.
He said, if you have nothing to hide, I will set up an email account. I want you to come up and give me all of your passwords and all of your account numbers because you have nothing to hide. He said, nobody's ever taken me up on it. And I thought, so we all have something to hide when you put it in those type of things, because I've heard the same thing. My life's an open book. There's nothing exciting about me. We still need to protect. And by now, say, I don't know how old this one was. It was at least 5 years ago, maybe 10. Back then, we didn't have nearly as much identity theft as we do now. Lord knows I've changed my credit cards so many times because I don't know why. But anyway, that's how we put those two together. So, I'm going to skip ahead a little bit if you don't mind. Here's another good example, a little bit more relevant, and this has to do with HIPAA, high-tech, and maybe some of the other health law. So let's go through different levels of privacy. The first one is pretty clear. We have, say, doctors, anesthesiologists, the hospital, they have access to your health information that's identified with you and needs to be kept private. That's the first level, right? That's a no-brainer. The next thing we have, next level, is insurance providers. Machines that record your personal health data, things like that. So not exactly facing, but they have your health data as well. That also needs to be kept private. And all this we're talking about, because it's in a hospital, is most likely covered under HIPAA. So, but there's other things as well. Finally, there's more privacy that comes up. And this is maybe the software providers or a CRM or something that holds your data, that your data passes through. Or the insurance. And then if we want to use GDPR terms, the controllers and the processors, if any of you are familiar with those. Those types of things we're talking about, both of them have regulations and are required, and as we move more and more, the law updates, especially with the CCPA, we get into, say, even, personal injury attorneys might gather some of your personal health information, and these are even further down the line than insurance payments, the banks that pay the hospital, the credit card companies, on and on and on. The people that process your sick pay, you see, this isn't just a one and done. It's a cascade of events where your or my personal health information from whatever reason we were in the hospital trickles down into all sorts of people have our data. There are several rules, as I've listed these people, we're not going to go through them, that apply to different ones. But here's an example. Remember I mentioned HIPAA, right? A covered entity. Everybody says HIPAA, right, with everything health. That's not accurate. HIPAA applies only to covered entities. So insurance providers, medical doctors and stuff, we'll get a little bit into the federal laws later. There was another law that happened called High Tech that kind of sewed up those loose ends, and that took care of businesses that aren't necessarily covered by insurance. So if I see a doctor today, I pay him in cash, he doesn't accept insurance, he's not covered by HIPAA. So, I hope this is new information for you guys. If not, okay, good. So,
You never have that because I never have cash.
none of us do, right? It's all credit card. Yes.
Does that include dentists?
Dentists, if they pay for cash, how the doctors get in there is if they under insurance, if they accept insurance, is the highest level to think about what's covered under HIPAA or not. There are other laws that they will be covered under. High Tech is one that covers businesses, that kind of fills the gaps in HIPAA. There's a ton of acts and laws. Let's move on.
Lee,
So-
just a quick question on HIPAA.
Yes.
Can you just remind me, is that a remedial scheme as well as a prescriptive set of rules? Or is just regulating conduct with no ability for an aggrieved person to bring a cause of action or seek out?
There is no private cause of action under it. To my chagrin, I would make that.
Because there's the Federal Privacy Act, which I've defended the federal government in suits where it's violated that act. But I didn't think that HIPAA was a part of that, so I thought it was distinct, but I wasn't sure I could remember.
That would have been super interesting. I wish you would have been here. I would have loved to hear about that.
Sorry.
No, I want a dialogue, really. So here's a few other quick examples and then we'll move on. So, HR department. So as they collect information, say the employee fills out a form for insurance, right? The employee and their spouse. Now let's look into what is a sensitive category, especially in GDPR. When you fill out the spouse's name, if that spouse is of the same gender, suddenly we've disclosed sensitive information without even intending to, and we've received it too. We might have a good idea of sexual orientation, right? Because of a same gender couple filled out all these insurance things. We didn't ask for it, but now we have it. Here's another example. I don't know if they have these on planes or not, but somehow we checked, say this morning, or somebody else, they're serving us lunch, we checked the kosher option. Suddenly, without intending it, they may have an idea of what religion we are, right? So there's other ways you can back into some of this sensitive information without intending.
But knowing about it, it isn't the same as being discriminatory. Like, there has to be some affirmative action against that type of person, and you're saying, so I just don't see where it would be, how it would lead to like a lawsuit. Like, if you knew that I'm Jewish because I ordered a kosher meal, so what? Like, where are the damages?
Well, I had this trouble in law school because I think mathematically and science, and I'd skip right to the answer. And my law professor would shake his finger at me and say no, and I would hope he would say, you need to think like somebody who's a humanities major. We need to go through step by step by step. And there's a few steps there. You're absolutely right with that idea. But let's back up a little bit. What we have is a cause of action potentially down the line a little bit. And that's if people mess up in the middle. So it's not necessarily disclosing you're Jewish, or Muslim or Christian or whatever, it doesn't matter. But if you disclose it, and now under, for example, CPRA, sensitive information, we don't handle that carefully enough. And if you're a big enough business to be regulated by the CPRA, we have to have now a yearly audit that we disclose what sensitive information we collect. This is marginal of whether it be in there or not. And we have an audit, and then we also go through and say if we are disclosing sensitive information and collecting sensitive information, what's the benefit? I'm getting a little bit ahead of myself. What's the benefit of having it? Is it worth having? And how are we protecting it? And then it falls into other things. So in that way, if we mess up by accidentally breaching this and not treating it like we should, now we're in trouble. For example, the FTC, which is next on my list, when they're one of the big enforcers, and I'm sure you all know this. Did you have a question?
Well, the employee who's entering this data knows now that you are Jewish, and because they are, whatever, bigots, then they start to harass you, and they are happening to be in a supervisory chain for you, and now your employer unknowingly is liable for harassment based on your religion. That's how you have liability for this mishandling of information, even if it wasn't exactly mishandled because it was handled according to the policy, but the person wasn't trained to not use this information to harass.
I love privacy.
Oh,
Privacy.
yeah.
So it gets even more interesting than that. If we want to take it one further down, it's applicable come January 1st, CPRA, right? There was a provision in the CCPA that they kept basically pushing out, and the CPRA did it as well, that expires this January, and that is for all of these requirements, you know, we'll get into that. But, sorry, I'm just looking at the slides.
If they're not showing
That's
up?
fine. No, I'm not following exactly. We're going to cover most of what's in the slideshow and in your materials, but we're doing it in a different order. Back to CPRA. This provision, when the California legislature met, I think everybody was talking about August, but I think they also met, if I'm not mistaken, in October. They didn't push this back out. So all of the employees of a business are also going to be subject to the data privacy rules of the CCPA and the CPRA. Hopefully do something, but that will change it too, because now you'll have all of these consumer rights of the CPRA now applicable to the employees of a business that meets the threshold. I'm going to skip ahead a little bit so we can get into this California law. Let's see. FTC, let me cover it real quick. Are you guys familiar with how the FTC brings suits? So, one of the main enforcers of privacy law is the Federal Trade Commission, going through and calling it unfair and deceptive practices that involve the collection, use, processing, protection, and disclosure of personal information. So, the FTC views its enforcement in 3 general categories, and this is my idea, this isn't anything that I know of from the government. So it's investigation, and this makes sense, I suppose. Investigation, enforcement, and then litigation. And when you think litigation, I'm not a litigator, I haven't litigated in years, I think as I alluded to, it's been at least 10 years since I've set foot in a courtroom. But having said that, it's normally with the pleading or complaint or whatever is delivered with the FTC, out comes also a settlement agreement, and with that comes a consent decree. That means we'll settle it out, there's no penalties here, but you agree to do this many things to kind of fix the problem. And now they've got you because when, or whoever, if they mess up again, now they violate federal law and the consent decree, and they're in trouble. So, it's not always, as you were talking about, it's not a Jewish problem. It's a lot of times there's several steps in here, kind of like a cascade of events. Although there are some no-brainers that go forward. Anyway, so
What are the no-brainers?
we'll get there.
Okay.
So a lot of times the FTC brings an action with a data breach. You can clearly see if somebody said in their privacy policy, I don't know, let's take it high level, we will protect your data, and you have a breach, clearly they didn't protect your data, right? Even sometimes if it wasn't totally enumerated in what the regulations were, that's a lot of times how the FTC goes after breaches, the claim of misrepresentation, and maybe deceptive practice. So, everybody knows you have to have a privacy policy on your website, right? That's under an old law, so the California Online Privacy Protection Act. The CCPA and the CPRA take a lot of the spotlight nowadays, but this is a good one. If you're collecting data, and there are a lot of things in here that we'll see now are in the CPRA in a second. A website that collects data from the consumer needs to have a privacy policy. They need to, let's see, conspicuously post their privacy policies. Normally now we see it at the bottom, right? It has to be on the landing page generally, excuse me. What information they're collecting. This is the business whose website it is. How they use it, how they protect it, who has access to this data they're collecting, and how to request copies of a person's profile and edit or request it be erased. Personal information under CalOPA includes first and last name, home and other physical address, email address, telephone number, social security number, any other information that permits. And if you're writing this down, it's easy to find, but I will go slower if you'd like me to. Any other information that permits online or physical contacting of a specific individual, information concerning a user that a website or online service collects in personally identifiable form.
Do you have like a website that uses a third-party vendor to run their credit card information to? Are they still going to be liable for collecting information?
Yes and no. It's safer, and we'll touch on that in the California law, but it's safer to push it out and let somebody else handle that data. However, we will need to watch contracts to make sure they are compliant as well. So, that's a simple answer. Does that work?
Yeah.
Okay.
I'll take it.
So can I ask a sort of a follow-up to his question? So let's say you're a small law firm. Hello. And you process credit card payments through Square,
Okay.
right, third-party vendor. And Square dumps the money into your bank, my bank account, okay? So am I liable for a credit card breach, or is Square?
Square is, but you do have a duty to make sure that, look into to make sure they're secure in how they handle that information. So you can't go audit their servers and stuff like that. But you really should look into making sure, and this is where I go through without going into whether if you're a small law firm, I doubt you have over 25 million in revenue. I hope that's no offense, I don't. So you're probably not prone to the the CCPA or the CPRA. So even if you're not prone to that, it doesn't mean that you don't have to protect your client's information, right? We have to, even outside of all this data privacy stuff, we still need to keep things confidential and secure. So you still need to do that even if you're not prone to these laws. And in that, I think, without going through the law, and this is my idea of general feel, you should really make sure that, one, I think to cover your own bacon, the clients know that it's going through Square, right? So it's not you. But also look to make sure, at least poke around and see in the contract, does Square promise it will keep the data safe? Do they have adequate thing? Oh, maybe when you sign up, we keep it in the cloud, we use up-to-date security, we do audits, blah, 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 blah. Okay, that's reasonable, right? It seems like they're up and up. I think Square would be. But it behooves of any of us, including me, to make sure that these providers that hold our client information and sensitive information do it reasonably, right? Because if we're all audited, I would rather some AG or somebody, I did everything I was supposed to. That's a lot, that helps a lot, instead of, I just didn't care, or I didn't even bother looking.
So you mentioned that if I collect on the website, my $25 million law firm collects on the website, any personally identifiable information that I need to provide the client with a request to erase mechanism.
With not many people look at the CalOPA with the website requirement. That's kind of why I hit on it, because it's interesting, CCPA, I'm sorry, I keep jumping around, and I'm right on the cusp of getting into California. CCPA,
One questions maybe.
yeah, but you're right though, because that does require, and I can't think of something off the top of my head where somebody said, I wasn't given under the CalOPA the opportunity to delete or edit my information.
No, my problem is they asked me to delete all of their information, but I think a lot of the information I've collected is part of my attorney work product, which I'm supposed to keep because if this client goes and complains to the bar about me, I would like to know what we discussed.
Well, and that's towards the end of my materials. There are exceptions to keeping information. One of them is a business purpose, one of them is for litigation. There are several reasons. For example, and just to go through that, and maybe we'll skip a little bit when we get to that point, but since you brought it up, clinical trials, they require information to be kept for 25 years, right?
Yeah.
So, and you might keep it through statute of limitations. I would recommend we all keep our client files and data and stuff, at least with the statute of limitations, just to protect ourselves in case there is a problem or a complaint or litigation. There are other industries that, for example, I don't know, download streaming. It's a second, right? For that one bit of information they took and gave back, they don't need to keep it any longer than that. So it really depends on what industry you're in. And remember this whole patchwork of all these laws depending on what we're doing and where we're going and who we're under and what state and what country and everything else. Those all come into play too. So, are we an education that receives funds from the federal government? That's a set of laws. In fact, it's on one of our slides, some of these federal agencies. Ashley was going to cover that. But I know enough to explain that, you know, and I might as well do it now. California and all these states are giving carve-outs when we go through. By the time I'm done with California, I want you guys to look at what's happening in Virginia, what's happening in these other states, you know, oh yeah, that's the same, from state to state to state. It's very similar, a lot of these ideas. For example, 25 million, I think is in most of the ones I'm going to cover today, besides California. So you'll start seeing these common threads go on and on and on. So instead of looking at 50 different sets of privacy laws, we can go through and get the idea of these general ideas and say, okay, yeah, 25 million. Another state? I don't know, I haven't read it. But with 13 I know of at 25 million, I might bet, you know, $10 it'll be another 25 million, even if I haven't read it, because that's what they're all doing, to get a general idea of what's going on. I think I lost your original question.
No, you're good.
Okay,
You said there are exceptions, and we will get to that.
yes.
And then you said we don't need to actually read the patchwork, because they kind of copy.
Well, the states will carve out federal laws so they're not overturned and violate the Dormant Commerce Clause. So you'll see that the CPRA is doing carve-outs as all these other states are as well, excluding HIPAA and stuff like that.
So are you talking about some sort of model act that's in progress?
For
This sort of thing? Like, you know, a uniform trust act and the uniform...
United States wide, they're pushing it. There's a lot of pushback.
Why?
We want to be more business friendly in Tennessee.
Just for various reasons. I mean, it's unlike GDPR, I think, business, I think a lot of different variabilities. I don't have a good answer for you. Let me put it that way. I can list a whole bunch of, this is what I know, this is what I think would be going on if I was in their place as to why, but I haven't heard of any good reason why they're not. How's that? So there's always one in the works. Let's get on to California. Before I go in here, well, let's just go on to California. So CCPA versus CPRA. And I'm going to go through the CCPA in good detail first, even though it's sunsetting out in January 1st, in a couple months. Most of it has carried over and is irrelevant to the CPRA. So we need to understand this in order to move on. Whether we understand it under the CPRA or CCPA, it's the same concepts that are going to get used. In fact, how I'm going to present the CPRA is what's different between the CCPA now that we have that and what has changed in the CPRA. And it's not going to be a whole lot. But that's why we're going through, and when I wrote this, I thought it makes sense to me, but let me explain why I'm dealing with the CCPA if we're going to be under CPRA in a couple months. So, the first step is to know who is covered or who is under the CCPA. So, we have for-profit businesses, not non-for-profit, for-profit businesses that collect California resident consumer personal information. The entity determines the purposes and means for processing the personal information. It does business in California. And this is CCPA, remember, it's going to change a little bit in the CPRA. And is one or more of the following: 25 million in gross revenue, 50,000 personal information from a person, a household, or a device. I'm going to explain that in a second because I was surprised when I first heard about what was going on with device, and I'll explain that in a second. Or 50% or more annual revenue from selling consumers PII. Selling is a key word here, and that's changed a little bit too. So, device. Do any of you know where I'm going with this?
Cell phones?
Yes. So, let's take me for an example. I'm a person, right? 50,000 is the number we have to reach. They've moved it to 100,000, and here's why. Here's 1, here's 2, this is a device, here's 3, I have another computer in here in case the plugs didn't work, there's 4. So you're looking at somebody just in this room, it's in the way to if a business collects 50,000 bits of information, these are the devices, they dropped that out. But for a few months, we still have devices. So suddenly, I had a client once who had several clinics in California. I went through it and was looking at, are you subject to the CCPA? This was a few years ago. It's I don't know, I don't think they had more than 20 clinics, maybe under 30, I don't remember. I thought they're not going to be CCPA, but I had to ask. They had kept all of their client records for I don't know how many decades. With all the client devices, say everybody has a cell phone, suddenly we've doubled that. If they have something else. I think we got up to, when we started getting close to 50,000 through this small group of clinics, why are you holding on to client information if you haven't seen them in 20 years? I don't know, just in case. Don't, right? There's no reason, and we'll see that, and that's coming into law as well. But just for the sole purpose, there's many purposes not to hold on to information that you need, and now it's codified, but just so you're not under these rules, right? So remember, it was one of the following: 25 million, 50,000, or 50% more. They would have made that. Naturally, we deleted it, and we didn't have to worry about it. So, what's a California resident or consumer? Did I mention I moved to Eagle, Idaho 2 years ago? Guess what? Any business that collects my information, because my practices are still here and I teach here, I count. Even though I don't live here anymore, it doesn't matter that I come here once or twice a month, every month. I'm still a consumer because I pay taxes. It kind of boils down into who pays taxes, right? So a natural person who's a California resident, however identified, including any unique identifier. So resident means every individual who is in the state for other than temporary or transitory purpose, and every individual who is domiciled in the state who is outside the state for a temporary or transitory purpose. All other individuals are non-residents. That's a resident, but remember, I'm a consumer. So it's residents and consumers that fall under the CCPA and CPRA. What is personal information under the CCPA? Any information that identifies, relates to, describes, or is capable of being associated with or can reasonably be linked directly or indirectly to a consumer device household. We have identifiers, which are IP addresses, passport numbers, email addresses, certain categories such as signature, education, employment, protected classification characteristics, commercial information, which means a record of personal property, services or goods you purchased, etc. That's commercial information, biometric information, internet information, geolocation data, audio, electric, visual, thermal, olfactory information, or inferences based on behavior, which AI and inferences based on behavior, especially in advertising, has really seemed to be a hot button in the last few years for a few reasons. What is a sale? Remember I said sale of information? Sale is, a lot of these terms are going to be very, very broad, more than we might think initially. So a sale of information is selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating information, orally or in writing, or by electronic means. Doesn't have to be electronic. The consumer's personal information by the business to another business, and it doesn't have to be for money or other valuable consideration. Is that one of the broadest definitions of sale you've ever heard? Mm-hmm. We're going to get a lot of broad informations in this area. Who's a party? With a half hour, I'm going to, do you guys mind if I talk quickly? So here's the thing. We're all this. I have to present, but it's more, I would rather give you guys the choice because you're the ones listening. So given what I'm talking about, we can keep going through California law. If we run out of time, which we might now, we can shorten this California law. I can talk quickly to give you the basics. We can go through what's happening in other states. Which is somewhat relevant now. It's a world marketplace, right? At least any of our clients who do business in other states, if they do, might be relevant. I definitely, like I said, want to hit the New York Fair Information Practice Policies is something I wanted to do as well. Yes?
I would be really interested in hearing the differences between the CCPA and the CCRA.
And that's very relevant to us because we're all in California, right? Okay. So we'll continue through that. What I will set
Specifically
aside.
the differences.
What?
Specifically the differences, like what are the changes?
Just tell us that this has a very broad definition, basically everything under the sun, and then we can read we don't need to do that. When you read sale, we kind of got the picture of like,
Okay.
we just defined it to include every possible human activity that including pillow talk.
Okay. All right, so we will skip ahead a little bit more. Let's see, parties, we have 3 types of parties that are generally that collect personal information. I'll skip through this quickly. We have businesses, those are usually have the most obligations under the CCPA and consequently the CPRA. They've added a new category in the CPRA. These have a direct relationship with the consumer. The service provider, these are, remember, groups that collect personal information. The service provider is exactly that, the service provider. They collect information, and they don't do anything else with it besides serve the business. Payment processor, etc., is a good example of service provider. Then there's this category called third party. It's kind of amorphous. Every time, and including the CCPA, defines it as a third party has the business personal information, but they're not a business and not a service provider. That's what a third party is. So to make sense of that, the easiest thing for me to think of is a contractor, like us, right? We may get personal information, we use it for our purposes, we're not going to spread it around. We're certainly not a service provider because we're not regularly processing payments or whatever else, and we're not the business, but we're working for the business. To me, that's the easiest, but that may not be totally accurate. The best way to think about it, if you're ever pushed for a good answer, is a third party is not a service provider or the business. Because that's how it's
One
defined.
legal or one of those upload services,
I'm sorry?
like one legal or one of those other legal vendors that uploads information to the courts.
That's a service provider.
Because they do it regularly.
Yeah.
The CPRA,
Hey, I have an idea. My daughter takes something to court. Well, that was a possibility, and she can, like, because she's there, she can read the cover sheet and know my client's name and address maybe and whatnot. So, but she's not regularly doing this service, just I asked her to do me a favor.
Let's look at what the consumer's privacy rights are under the CCPA, and they are
I'm getting
increased. I'm sorry?
Getting
Under
scared.
the CPRA. So we have more, but under the CCPA, and we will add later, and I will tell you why, and then we'll compare it to the GDPR, which I personally think is interesting. The privacy rights under the CCPA, the right to know what personal information is being collected. I'm going to say me. I have the right to know under the CCPA what personal information is being collected about me from the business. The right to know whether my personal information is sold or disclosed and to who or whom. I have the right to opt out of the sale of my personal information. And I'm going to mention this a couple times. Who here has heard of global privacy controls for your browser? Good, I'm glad. For those of you who haven't, this is important. I've done it, it's easy to do. I clearly am a Mac user, Safari doesn't have it, although DuckDuckGo, Firefox, those ones do as well. You just go into it, you actually slide the button across. What that does is send information, and this is why Sephora got in trouble, because they weren't detecting the global information. This is one of the things that got them into that $1 million settlement. And then they had to fix what they should have been doing in the first place, and pay $1 million to boot, and a whole lot of bad press. So what that does is send a signal, don't collect my information. It's effectively an opt-out. So it's easy for us to do if you're using the right browser. It tells the business or whoever's collecting your information, don't collect my information. You're opting out of certain things. It's very easy to do. It's, I don't really see any downside to it. I'm sure there is somewhere. Personally, for what I do in my own practice, I don't see a downside to it, and I'm telling you to as well, because it's an easy opt-out.
Is it a settings function of, say, Google or something?
Just look it up. That's what I did first. Yeah, it's not, well, I don't use Google Chrome, so I would imagine it's in Google Chrome. I know that when I need other things, I move from Safari to Firefox personally, and so I set it in Firefox. Look up global privacy controls, GPC. What Sephora did is they weren't picking up on those. So even though people slid it over, the little slide or whatever it is, and said, I'm opting out, don't collect my information, don't sell it, Sephora wasn't able to pick that up. And so functionally they ignored it even when the people made the request, and that's one of the things that got them in trouble. Their website wasn't picking up on the GPC opt-out. So back to consumer privacy rights. Who, what, why, how, when, and where. That's not super accurate, but you get the idea. Who's getting my information? What are you going to do with it? How are you going to protect it? How are you going to use it? How long are you going to keep it? All these things as if I was loaning, I don't know, my lawnmower that I really cared about a lot. It's mine. It's my information. I have a right to know what they're doing with it. It's a little bit different clearly in data, because here we have what's being collected, who's getting it, is it sold or disclosed, and to whom? Can I opt out of the sale of this? Can I access my personal information? I have the right to, and if I exercise any of these rights, they put this in the back end. You are not going to be punished for exercising any of your rights. This is in the CCPA, no retaliation for exercise of these rights. And also the right to equal service and non-discrimination for exercising your rights under the CCPA. Business obligations, of course, duty to comply, post notice of consumer rights. Those things I just mentioned, usually they happen in the privacy policy, although sometimes you can break it up if you don't want this huge document. But it does need to be posted. Inform the consumers of data handling practices and respond to consumers. So if a consumer requests one of their rights, for example, to review their data or delete their data under the CCPA and the CPRA, they can also review it and edit it or request it to be updated, which is in the business interest anyway, in my opinion. The business needs to respond in 45 days. They can, if they respond, they can... CCPA and the CPRA, it's both the same. Yeah. There's a lot of carryover, which is why we're going through the CCPA first. If they respond within that 45 days, they can push it out to another 45 days, giving them 90 days. And we will hit your question later about responding and using these rights, specifically usually to delete the data. Of course, the business they're required to keep it secure, that they have a duty to train employees, and who was I talking to? I think it was Joe. It might not have been. But even they were talking about, and I can tell you, train your employees. And this is easy for breach. This isn't in the presentation, but people love to click buttons. They love it. Click here, click here. I get phishing emails all the time. Click here. Train them. The best training I ever got, believe it or not, was from the federal government and the Social Security Administration. We had some really, really good trainings. So, having worked for county, state, and federal government, there's things each one does better than the other and things each one does worse than the other. And then you compare it to private industry, it's a whole different ballgame. But one thing the federal government did, at least in my agency, was train us on data privacy and security really well. And that's important, and that's an obligation of a business. And I just want to tell you guys, because that might also be relevant to your own law practices. If it's not just you like a solo, train your staff, because if there's a breach and they click on something, not only could you get in trouble that way through other things we may or may talk about today, but it's also a huge inconvenience and expensive. And is bad press. You inform your clients there was a data breach, right? If you're required to or not. Very, very easy, like anything. An ounce of prevention is worth a pound of cure. Easy not to click buttons, and you always hear about data breaches and things like that, besides leaving a laptop at Starbucks or something and you turn around and it's gone. Clicking on an email. And there's all sorts of, that's a talk for another day, but they are getting really good. It's no longer a rich prince in Nigeria that wants to funnel money into your account and pay you $10 million for doing it. So, private right of action, I think you were asking about a little bit earlier. They were with the data breach. There were causes of action. The Supreme Court shot that down a few years back by saying there was no functional harm by just the threat of a data breach. The Third Circuit recently came up, and I brought the case in case somebody's super interested, but suffice it to say that it's a somewhat recent decision, the Third Circuit, and they said that a data breach, imminent harm, when the Supreme Court said is not enough for a cause for standing, Third Circuit came in and said that plus, say for example, emotional distress or laying out money for credit monitoring. Now you have harm instead of just imminent threat. Okay, so that's somewhat recent. So we'll keep an eye on that, but but people were wringing their hands saying the Supreme Court did away with imminent threat, and causes of action, so we'll see where that goes. If it's relevant to your practice, I suppose. 90 minutes, we have a little bit less than half an hour. So let's go through.
Oh, but you can
And I promised I'll do New York because that's going to be relevant to us. And we'll see what the state of New York thinks is important for all of us attorneys to know in our own practices. Therefore, we have to study it in CLE. And I'm pretty sure California will be close behind because of all the privacy stuff we have in our state anyway. So privacy requests. So if they request information such as to delete under CCPA, here's some of the ways that you can refuse it or push it out. For example, consent to use. If the person gives you consent to use their information, you can keep it because they've consented to it instead of deleting it. If it's part of a contract, for example, in order to render my services to you per this contract or carry out my obligations under the contract, I need this information. There's another reason to refuse to delete it, another exception, I should say. Another exception would be legal obligation. Somebody brought up in here, maybe it was me, potential for litigation. I want to keep this information beyond at least the statute of limitations. So I have a legal, or somebody else, there's a litigation happening elsewhere. reason to keep it, or any other legitimate business purpose. If some of it should be deleted and some of it you find an exception to retain, when you respond, you have to respond and give the reason why you're only deleting part of it. What's not in the CCPA? So finally we're getting into CPRA concepts. Before we leave the CCPA and only touch on it, anybody have any questions? Okay. New concepts, sensitive personal information. I'll list that out. This is similar to sensitive data in the GDPR, if any of you are familiar with that, and I'll list out the differences.
What does GDPR stand for? GD, I get PR is privacy rights, but what's the GD?
Oh my gosh. You know, I can't think of it off the top of my head, it's been years. I can look it up on my phone if you want.
Okay, don't worry about it. Sorry.
Global data.
Global or general data.
I think it's general,
Yeah. So, sensitive personal information, collection limitation. This is new in the United States. Not new of those of you familiar with GDPR or other countries, but it's new for us. Collection limitation and purpose limitation. That's just what it sounds like. I see people on their phones. If you figure out what it is, just yell it out. Did anybody find it?
I can't connect to it.
Whatever, we'll hear it when it comes out. So this is data minimization. Have you guys heard of data minimization? Collect only what you need and keep it only for as long as you need it. That's now codified, but it's also, in my opinion, good business sense. If we're liable for this information we have, the less you have, the more that reduces your liability, or at least notice to people that it was breached. If you don't need it, why keep it? It's like a pair of pants I had when I was 20. There's no way in hell I'm going to fit back into them. Why do I have them in my closet? Get rid of them. Anyway, sorry, more information you probably need to know about my personal life. But anyway, you get the idea. So data minimization is new to us. Consumer rights. If you remember, there was only the right to delete under the CCPA. Under the CPRA, we now have the right to edit or update, which just makes sense to me. The right to limit the use of sensitive information. You can actually limit their business use of sensitive information. So, business obligations, no secondary use, that's not exactly new. Auditability compliance program, I touched on that earlier. Remember the audit and risk assessments to give to the CCPA, California Privacy Protection Agency, the new agency that was created last December. That's why they rushed into the CPRA. It was introduced in November, passed in December. So the CPA could be put in place and start working on the CPRA and hear cases. It's a 5-member board new agency in California as of last December. And the last one is different. The CCPA was under the Attorney General for enforcement. As I just mentioned, the CPPA is now the enforcement agency of the CPRA, but that doesn't mean the Attorney General is out of the picture. They still have enforcement ability, so I haven't seen it yet, but I believe technically you do have 2 agencies, the Attorney General and the CPPA, that could be looking at privacy actions. I haven't seen it yet, I don't know, but it doesn't seem to be, entirely not possible. So, CCPA, as you know, was rushed into effect in 2018. We went through different iterations of it. Privacy was seen as an inalienable right in our California Constitution Amendment of 1972. The CPRA was passed in 2021. As I see, one of the main purposes behind the CPRA was to put into more fair information practice principles. And I'm just going to read really quick, just so you know what they thought of fair information practice principles were in 1973, okay, through the federal government. It's called the Records, Computers, and Rights of Citizens. So there must be no personal data record-keeping system in this computers in 1973. There must be no personal data record-keeping systems whose very existence is secret. There must be a way for an individual to find out what information about him is in a record and how it is used. Does this kind of sound familiar? It's pretty wordy with what we're hearing, but look what they were doing 50 years ago. There must be a way for an individual to prevent information about him obtained for one purpose from being used or made available for other purposes without his consent. There must be a way for an individual to correct or amend a record of identifiable information about himself. Look, we just came up with way to correct. They said this in 1973. Our state CPRA just put that into effect, 50 years later? So a lot of these principles you see, as I was saying, carry on. These are 50 years old. Any organization creating, maintaining, using, or disseminating records of identifiable personal information must assure the reliability of the data for their intended use and must take reasonable precautions to prevent misuse of the data. To me, that's super relevant. 50 years ago, and we're just putting at least one of those things into our California law, CPRA. That's what I mean by common thread. I'm going to take a step out now because I'm getting excited about this. Some of the main things you see are transparency, right? Here's what, in my opinion, going through this, a lot of this boils down to. When you're collecting people's data, don't hide the ball. Tell them what you're doing. These privacy, in GDPR, you have to write your privacy policy and all these things in plain English, clearly, which is sometimes we can't avoid as lawyers, but when we're talking to non-lawyers, it needs to be written plainly. We're not hiding the ball. We're telling them what we're doing with it. And that includes not using it for a purpose we didn't tell them about. Yes?
How do we, with my clients, I've tried to do some privacy agreements or policies, and the biggest challenge to me is figuring out what they're doing, not what I want them to do. So how do you, in terms of client management, how do you get them to kind of tell you what it is that you're doing with the information so that you can actually accurately write the privacy agreement?
How do I personally do it?
Yeah.
I scare them. Yeah. Because, look, we just talked about the Federal Trade Commission coming down hard on people for deceptive trade practices. They promised in their privacy policy, and it's not one reason, but that's a big one. It's like, don't lie to me, because you're making a promise to all of your consumers and residents out there. This is the data like I'm talking about. This is what you're taking in. This is transparency. This is how I'm going to protect it. This is what I'm doing with it. And anything not enumerated in here, it's not exactly accurate, but basically assume that if there's a breach, if you told them you're doing one thing and you do something else, that's a problem. You lied to them. That's a deceptive, you broke a promise. That's a deceptive trade practice, right? Sure. So if they, yes?
So maybe jumping ahead, one of the few private actions the consumer has is under business and profession 17200, which is deceptive trade practices. Do you think, in your opinion, that we're going to see privacy cases be coming through 17200 for the private right of action?
I haven't looked at that, if it doesn't step on the toes of the federal government. Because like other California laws, they don't want this overturned and running afoul of dormant commerce clause. So if it's not running afoul of a federal agency, then probably yes. Also remember, there's other agencies, not just the CCPA or the AG, that have jurisdiction over these privacy actions that are enumerated in these acts. But we also have all sorts of other federal acts, for example, protecting children, COPPA. I don't know what that stands for either, whoever asked that off the top of my head. Children's Online Protection Privacy Act, is my guess. But they really carve these out, and other state laws that go through in California. For example, we just looked at two, we looked at three: CCPA, CPRA, and the CalOPA for websites. So through that, if the same entity enforces it or not, it gets, I don't know, smarter people than I am decide, what's going into these legislative things and who has.
I'm just going to mention, 17200 has been used for years as sort of one of those subsidiary claims that gets thrown in when people are suing for data privacy breaches and the like. courts are consistently saying that's a statute that doesn't give you an opportunity to get money back. It does allow for restitution, but in a privacy breach, the question becomes, well, what's the damage? So it's been around for a while, but I don't know that it's a vehicle for getting money.
Always a question.
Also, you
Thank
do
you.
need those monetary damages. But once I figure it out, I'll let you know. Because that's where I'm getting the 25
That's where the 25 million.
Yeah. What am I doing in employment? This is so much more lucrative.
So, new CPRA thresholds. Who is under the CPRA? 25 million in gross revenue. That's unchanged, but remember we have common branding of entities, and I'll fly through this. I see it, for those of you familiar with trademarks, kind of the same, likelihood of confusion. If it's a common trademark, if it's a consumer may say, in likelihood of confusion, those marks are so similar. If you're applying for one, somebody has it, is it the same business? I don't know. That's likelihood of confusion. That applies now too. So, I'm not going to spend a lot of time on that because it gets sticky, but I just want to bring it up. So 25 million in gross revenue. This is CPRA. That's unchanged. Buys or shares information, or buys, sells, or shares information. Shares is, it sounds very broad. It's not. It has to do with targeted advertising. Derives, PII, the number has now gone up to, like I said, they deleted devices, and it's 100,000, not 50,000, which...
Of what?
Personal information collected, like data points.
Okay. They extend it to nonprofits?
It's still
It's
for
still just
profit.
for profit? Okay.
Yeah.
Is it, do you think, wise or best practices for a nonprofit to follow this if they are collecting a lot of personally identifiable information from their volunteers?
I think so.
Yeah, right?
Right, like I was talking about. Transparency. What are you going to do with the data? You protect it. You tell people what you're going to do. You don't use it for something else. You protect it. It makes sense, whether that's locking your doors, locking your computer screens, not leaving your laptop out, encrypting your emails, encrypting files, etc. Depending on, and also if it's sensitive information, giving it more protection than being more careful. And I hate to say that not protecting it as well, you should protect everything. But really, if it's super sensitive information, you probably should make sure it's secure, not just normal stuff. It's a reasonability standard. And with the few moments I have, let me skip this in. So, here's the CPRA, the sensitive personal data. Remember I said that? You can limit it now under CPRA, right? And it ends at 11:30. And I'm flying to New York. Yeah, lots of airplanes today. So, sensitive information under the CPRA. Social security numbers, driver's license, financial account or credit cards, precise geolocation, racial and ethnic considerations, religious and philosophical beliefs, union membership, contents of mail, email, and text messages, genetic and biometric data. Things added under the GDPR, special categories of sensitive information. And these are new to the CCPRA, racial and ethnic considerations, religious and philosophical beliefs, union membership, and genetic biometric data. What the GDPR says, it includes that isn't in the CPRA so far, at least not enumerated out under their new sensitive personal information that can be limited, remember? Political opinions, health information, sex life, and sexual orientation. But you can see that we've headed more into the GDPR a little bit, in my opinion. I just thought that was interesting. So, in addition to the CCPA, we have data subject consumer rights. We talked about no access to your information, deletion of information, opt-out of sale of personal information, non-discrimination, data portability. You can take your data and move it. You own it, it's your data. With the CPRA added correct or edit personal information. We've already talked about this. It's not just delete anymore, which to me makes sense, and it's in a business interest to make sure your contact information is up to date anyway. And also opt out of sharing for cross-contextual behavioral advertising. That's the targeted advertising that I mentioned. So let's go into CPRA. I'm going to skip the rest of this. Adds children's information for those of you that may have clients that gather children's information, or I don't know if you're a guardian ad litem or something and you collect children's information as well. I think it's probably a bad example. But anyway, if you're collecting children's information, if they're 16 years old or less and they decline to divulge or give you the personal information, a business must wait 12 months before they ask again, or until the minor turns 16 before they ask again. The fines are now potentially treble damages, which is rare. So that's on the CPRA. The risk assessment and audit for those businesses under the CPRA, for those of you who have clients, over 25 million and meet the other COGS. There is, if you're a business that collects consumers' personal information, shall implement reasonable security procedures and practices appropriate to the nature of the personal information to protect the personal information. Expect an audit and risk assessment. In the audit, you define the audit scope, ensure, and I forget what form exactly needs to be filled out, but define the audit, ensure it's thorough and independently done, requiring cybersecurity audits and risk assessments for companies whose processing presents significant risk to consumer privacy or security. That's a once a year risk assessment and audit. Submit the audit to the CCPA and disclose if sensitive information, if you're including and gathering sensitive information, and if so, like I mentioned earlier, explain the benefits of using the sensitive information and the risk of processing. So
this is really inexpensive.
For clients who are under the
Yeah.
CPRA, yes, there's a lot more requirements, in my opinion. But, they're bringing in gross 25 million anyway, so they can afford it to
I'm
save.
sure there are tons of vendors who assist with this, right?
Oh, yeah. Well, the fines can be great. It's, and they need to do it anyway. Sephora didn't, and look what happened. I don't know how many Google records would come up if I searched Sephora breach and settlement. It's probably, I don't know, 10,000, 20,000. I'm sure that's 10,000 or 20,000 more than they'd want when you search that. Anyway, so Virginia, we went through California. We're done with California. Before I leave in the last 8 minutes, does anybody have any questions? I'm going to march us through the states. I told you they're very similar. I will show you how. I hope it doesn't take longer than 3 minutes. We will then go through New York and see what the great state of New York thinks that us attorneys should know and study for 1 hour every 3 years, and then we will be done. So, Virginia, effective January, just like the CPRA, 100,000 residents. California's 100. In fact, I think all of these are 100. Yes, 100 residents, just like us. So we're going to do Virginia, Colorado. I haven't even gone through this. Federal. There's some of the things that we touched on some of those. Patchwork at state level. Consent transparency, we talked about that. Data collection and data use, we've done that. That's fundamental. We don't need to do a history. Here's some of the states we're doing now. So I'm going to add a few. So there's California, Virginia, Colorado, Utah, Connecticut, and I think I put, no, I did. Those are exactly the ones I hit. So that's perfect. We'll go through that. This has to do with the enforcement action against Sephora. We're going to skip that. Expanding federal. Okay, and that's other stuff. We're not going to touch IP at all. Insurance considerations. So we've hit most of the slides. I just did it differently. Let's go
back to the state comparison chart. That was really good.
Okay. And that was Ashley's. There.
You could have taken credit for it.
So they all have 100,000 residents, right? Just like us. Virginia, Colorado, Utah, Connecticut. They are different dates. Colorado's comes effective this coming July. Utah is December 2023. Connecticut is also July. So Virginia and California are this January. Virginia has 25,000 Virginia residents, and 50% of company revenue is from selling personal information. All of them are going to have this too, provides data subject rights including access, correction, portability, and certain opt-out rights. All of these states do that, including us. Colorado, as I said, coming in July, deliver commercial products or services to residents of Colorado. Again, there's 100,000 sell personal data of 25,000 or more individuals. So either 100,000 collect information from or sell the data of 25,000 or more. Utah, a little over a year, December 2023. Similar to us, 25 million and controlling or processing data of 100,000 or more Utah residents, or derive 50% or more gross revenue. Remember, Colorado is 25, Virginia was 50, Connecticut, again, 100,000, 25,000, 25% or more annual gross revenue. Connecticut adds, and this is coming in July, requires data minimization, which we discussed, limited use, security, and assessments for high-risk processing. So you see, a lot of these are similar, even though they're different states. You know, there's a few things here and there, but one's adding data minimization, the other isn't. If you're like me and most of the clients are small, we're going to try and do data minimization unless there's no way they're going to be in Connecticut. Well, they need to doubt with CCPA, but just supposing they didn't, right? If you have an idea that they may branch out into that, include it. At least that's what I try to do, because now we don't have to play hopscotch around the different states and chase around what the law is. We just put it in there. And who's to say we've updated the CPRA? Who's to say these states that don't require data minimization aren't going to do it in the future anyway? Right? Kind of, that's what they call, in a way, privacy by design. We put the way we protect our data from the ground up. We have privacy by design in mind, and that's how we build it, instead of running around and chasing it after the fact. So that's what privacy by design is in Barney speak, like how I talk. Yes?
Is there an availment issue? Like, so what I'm saying is a lot of these companies are online companies.
Yeah.
Where, you know, they're in all 50 states.
Right?
Even because they're just online. So if Virginia doesn't have employee business contract rights and California does, then if the company is availing themselves of California, then they have to meet the CCPR, right? But like, if they're only, how can they only be in Virginia, is I guess my question.
It's hard to nowadays, isn't it?
So
Right.
How does that work?
What he's asking is that if, I'm going to just use one of, in Missouri, if there's a consumer in Missouri that contacts somebody in California, or a web-based business in California, and they exchange money for services, and they miscollect the business miscollects the consumer's data, that consumer could come to California and sue under California law.
So under the CPRA or CCPA, remember there's a threshold of who is there and who isn't. That's different than maintaining secure data. So if say a Canadian company collects data from a Californian, can the Californian sue the Canadian company?
That's the question.
Yeah, depends on what the data was collected. Is it under, education, under health, et cetera, et cetera, et cetera. A lot of, and I think this is more broadly, if it's a law to California, and I hate to say it, I'm sorry, it depends. Canada, by the way, I promised I would mention it, and I'm going to punt because I have 1 minute. We'll go a few minutes over if that's okay. I really want to talk about New York like I've been saying this whole morning. Canada, by the way, I promised I would mention it. It's very similar to GDPR with a potential of 8% of profits as up to 8%, which is huge in terms of punishment. So big punishments in Canada, very similar to GDPR. And then finally, New York. I have a few different things. The New York website that I read about. This I think is a little clearer. Here's what they will be required to take, and I imagine at some point in the future we will have something similar here. This is what New York thinks their attorney should know about for their own practices. Cyber threats, cyber attacks, data breaches, securing and protecting electronic data and communication, which is huge for those litigators here with, electronic discovery and all that stuff, and other things as well. Appropriate cybersecurity and privacy policies and protocols, compliance with professional and ethical obligations to protect confidential client and law firm data. Those are the main topics I'll go through so you can see what New York, but you see how this is similar to a lot of what we covered this morning for businesses is relevant to us as well. They're common themes. What information do you have? How you're going to protect it? How sensitive is it? Are you telling people what you're collecting? You need to protect it. We keep it for so long. So here's under the New York's continuing CLE board. These are the program areas for cybersecurity ethics. I suppose if I was going to do an MCLE or CLE rather for New York, I would have to be under one of these. Awareness and application. So New York's model rules, ethics, opinions, protecting the client. These are the main topics. So awareness and application, protecting the client, communicating and obtaining consent from a client, protecting the law office, storing, maintaining, and destroying information. So this is security of storing and data minimization in a way, right? All these common themes. Law office, electronic data and communication policies and protocols. Supervision. Inadvertent disclosures, law office failure, data breach, cyber attack, and cyber threat. So those will be the main topics to meet the CLE requirements in New York. I hope they sound familiar. If they do, I did my job in my opinion. Because that to me is what the state of New York thinks is important for all of us lawyers to know. I really hope it was a value add for all of you that